Welcome everyone, I'm Rilus Dana. Today we're talking about FDIC limits. This is a topic no one cares about until they do. So it's a topic that's not important until it is. So the FDIC limits refers to how much of your money is insured if the bank goes out of business. There's been a lot of talk about this in the news over the weekend. Obviously, Silicon Valley Bank. There's a lot of places where you can hear more information about that story. But here I want to focus on just the FDIC limits and how that affects your trust. Let me share my screen here. So let's go right to the FDIC website, Federal Deposit Insurance Corporation. And we're looking to see how it affects trust is the main topic today. Thanks for those of you that are watching live. If you have any comments, you can leave them. And I'll try to get to them if they apply to the topic. Okay. Revocable trust. Let's start with revocable trust. This is the main type of trust that most people do for estate planning purposes. And before we get in this, let's go over some of the basics. So what is a trust? So it's a legal document. The person that makes the trust is called the trustor. I call it the trustor. Sometimes it's called the settlor, the trust maker. You have the trustee who manages the trust, and then the beneficiary of a trust. So the persons that create the trust, they're usually the beneficiary as long as they're alive. And then once they pass away, the trust will name the beneficiaries as well as the trustee. So that's the basics of a trust. So let's look at these revocable trust rules under the FDIC to see how much is protected. All right, so we got 3 criteria we got to meet. So the first thing is the account, it has to be titled in the name of the trust, with terms such as living trust, family trust. And then they also talk about an informal revocable trust. So informal revocable trust would be a payable on death account, taught in trust, as trustee force, or other things. So if you're leaving a beneficiary, they're calling that an informal trust. Number 2, at the time a bank fails, the beneficiary must be entitled to his or her interest in the revocable trust assets upon the grantor's death. The FDIC recognizes life estate, blah, 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 but not contingent beneficiaries. Okay, so the grantor, that's what I was calling the trustor. So upon the grantor, the trustor's death, the beneficiaries have to be recognizable. The third requirement, the beneficiaries are living individuals and or an IRS qualifying charity or nonprofit organization. All right, if you meet all of those requirements, then we go to this next step. How many beneficiaries? Let's start with 5 or fewer. Now let me go back some too. I understand these rules have changed recently. So these are going to be effective April 1st, 2024. So we got to hold on a couple more weeks. These new rules are effective. But I believe the change is it used to be capped at 1.25 million. But I believe the new rules are gonna expand that. Okay, revocable trust, yes to all 3 of those. And let's start with 5 or fewer beneficiaries. So 5 or fewer, $250,000 for each unique beneficiary. Combines all the interest in all formal and informal revocable trust accounts at the same bank. So if there's 5 or fewer beneficiaries. So it's going to be $250,000 per beneficiary. Now let's look at a couple examples here. So here's one example. So we've got John. John's designated the same 2 unique beneficiaries, Jack and Jeanette. So he's got one account with $10,000 with Jack and Janet as the beneficiary, another account with $20,000, Jack and Janet, and another account with $470,000. So the total is $500,000, 2 unique beneficiaries, so $500,000 of coverage in this scenario. Now let's look at this example 2. Okay, so let's just scroll down here. So we got Lisa. So Lisa has one POD account, payable on death, to Sharon and Bill. And then Lisa and her husband Paul have a trust together that has $700,000 in it. So how much coverage does she have? All right, let's go back up here. So Lisa owns 50% of the living trust and 100% of the POD account, totaling $800,000. She has 3 unique beneficiaries between the 2 accounts. So the maximum coverage is going to be 3 beneficiaries times 250,000, so 750,000. And in this scenario, we have 50,000 left uninsured. So Paul owns 50% of the trust and has 2 unique beneficiaries. So his share gets 500,000 of coverage for 2 beneficiaries. All right, so it can start getting a little tricky here, you see. Now let's look at more than 6 beneficiaries. Now we also got another variable is, do the beneficiaries have equal interest in the trust? Let's start with yes, assume they have equal interest. It's going to be 250,000 per beneficiary. So just look at how many beneficiaries and 250,000 of coverage per beneficiary. So this, I believe, is new. I think it was capped, or it is capped until April, until these new laws take place. But now the number of beneficiaries. So what this includes as beneficiaries is if the creators of the trust pass away, how many people will receive at that time? All right, now let's say they don't have an equal share. So what happens if they don't have an equal share? Then it's going to be the sum of each beneficiary's actual interest up to 250,000 for each beneficiary, or minimum coverage of 1.25 million. So it's going to be the greater of either of those. So if it's an unequal shares, then it's the greater of 1.25 million or 250,000 per beneficiary. Okay, let's back up. Let's look at irrevocable trust now. So irrevocable trust established following the death of an owner. So irrevocable trust can be established by judicial order, statute, or by death of the owner of a revocable trust. So that's the most common way. So when the owners of a revocable trust pass away, that revocable trust becomes irrevocable trust. So I'm glad they noted this. So if the owner of a revocable trust dies, the trust becomes irrevocable, but it's still insured as a revocable trust. So even though it becomes irrevocable after they pass away, the rules that we just went over for revocable trust apply. Now, to qualify for coverage as an irrevocable trust, let's look at this criteria. So it's got to be, should meet the following 4 criteria. 1, it's got to be valid under state law. It's got to be titled in the name of that trust. The beneficiary and their interests are identifiable. So the identifiable beneficiaries and a non-contingent interest. Non-contingent means they're entitled to it right now. They don't have to do anything. A condition doesn't have to occur before they receive it. So as soon as the grantors die, they're entitled to receive it. So if all of those are met, then it's insured up to 250,000. And there's a note here saying that it's uncommon for irrevocable trust to meet this criteria because there usually is a condition. Now, the common irrevocable trust that I create is one, after the regular trustors pass away, it becomes irrevocable. And then we also do dynasty trust. For families with larger estates, it's important to protect the inheritance for the kids. So those dynasty trusts, I believe they would still meet the 4 requirements the way that I set them up. So if a child receives a dynasty trust and holds it that way, there's a default power of appointment that it would go to their children. So if a person received a dynasty trust and they had 4 kids, I believe these rules would apply. So those 4 kids would be the beneficiaries, and therefore 250,000 times 4, or 1 million of coverage in that scenario. So important stuff with the current headlines, current news situation. So just wanted to go live, discuss those, something I was thinking about over the weekend. So I wanted to brush up myself and remember the rules for trust. What we can learn out there, I would say, spread out your money. Make sure that if you're not holding too much at one place. And also you might want to reconsider your banks if you're holding things over the limit at smaller banks especially. Hope you found this helpful. Check out my other videos. You can go to the YouTube page or check out my website, riluslaw.com. I practice law in Arizona and California. If you need help setting up your estate plan in those states, or if you need help administering a trust or with probate, reach out to my law firm and we can help you out there. Thank you.